Let me tell you a story about Robert, a man who thought he had everything figured out. Robert worked hard his whole life, saved every penny he could, and dreamed of leaving a legacy for his kids. He wanted them to inherit his house and his retirement accounts, believing that would secure their future. After his first marriage ended, Robert remarried Susan, a woman with her own financial stability. He even wrote a will to make his wishes crystal clear, thinking he'd covered all the bases. He felt confident, relieved, and certain that his family would be taken care of. But he was wrong, very wrong. When Robert passed away, his will stated that his children would get the house, just as he intended. But the house was titled as joint tenants, with right of survivorship with Susan. That meant, legally, the house went straight to her, no questions asked. The will had no power over this arrangement. Then came the retirement accounts. Robert had never updated the beneficiary forms, so his ex-wife was still listed. Despite his intentions, she was the one who received the money. She got everything, not his kids, not Susan. This kind of mistake happens every single day, to families everywhere. People often think a will is a magic wand that fixes everything, but it's not. It's just one piece of a much bigger puzzle. Estate planning is like a complex machine. If even one part fails or is overlooked, the whole system can break down, leaving your loved ones unprotected. Robert's intentions were good, but his actions didn't match up. In the end, his kids got nothing. His ex-wife, who he hadn't intended to benefit, got a windfall instead. Susan, his second wife, was left in a financial mess, confused and frustrated by the outcome. This is why you need to pay close attention to every detail, not just the will, but all your documents and account titles. Estate planning isn't a one-and-done deal. It's something you need to revisit and update as your life changes. It's a living, breathing part of your financial life, something that needs regular attention and care. You've worked too hard to let your money and legacy slip away to the wrong people. Protect what matters most. Be diligent. Double-check your documents. Get it right for your family's sake. Your family's security and future depend on the steps you take today. Are you ready to get smart about your estate plan? Good. Let's begin this journey together. The most common mistake people make with their estate plan, the set it and forget it will, something you create once and never revisit. You sign it, stash it away in a drawer or safe and never look at it again, even as your life changes in big and small ways. Divorce, new kids, family moves, career changes, or even the loss of a loved one. Your will stays frozen in time while your life keeps moving forward. That's a recipe for disaster, confusion, and sometimes even family conflict. An outdated will can cause more problems than having none at all, leaving your loved ones to untangle a legal mess. Imagine, your kids are grown, but your will still names a guardian for them, or your ex-spouse is still listed as a beneficiary, or you left $50,000 to your brother when that was a big chunk of your net worth. Now it's a drop in the bucket, and your intentions have changed. Your will is a snapshot, not a movie. It captures a moment, not the ongoing story of your life. Life events, marriage, divorce, births, deaths, new homes, or even a new business mean you must review your documents. Divorce is huge. Some states disinherit ex-spouses in wills, but not on retirement accounts or insurance policies. Beneficiary forms override your will, so you need to update those too. Don't assume the law will fix your mistakes. Take control and be proactive. Review your will and estate plan every 3 to 5 years, and after every major life event. No exceptions. Put it on your calendar just like you would for a dentist or doctor's appointment. Treat it like a doctor's appointment. Regular, necessary, and not to be skipped. This is about protecting your loved ones from chaos, confusion, and unnecessary stress. An outdated will is a ticking time bomb, waiting to explode when you least expect it. Diffuse it before it's too late. No more excuses. Get it done, and give yourself and your family peace of mind. Let's talk about beneficiaries, one of the most overlooked but crucial parts of your financial plan. Many people assume their will covers everything, but your will doesn't control all your assets. Assets like 401ks, IRAs, and life insurance policies pass by beneficiary designation, not your will. These accounts follow the instructions on the beneficiary forms, no matter what your will says. That little form you filled out years ago? It overrides everything else, even if your wishes have changed since then. I've seen families heartbroken when a life insurance policy goes to an ex-spouse or distant relative because the beneficiary was never updated. The will means nothing for those assets. It's a common and costly mistake. You must check your beneficiary designations, now, and not just once, but regularly. Make a list of every account with a beneficiary: retirement, insurance, annuities. Gather the statements and keep them organized. Confirm who's listed as primary and contingent beneficiary. Double-check for accuracy and clarity. You might find an ex-spouse, a deceased parent, or even no one at all listed, mistakes that can cause real problems. Review these every few years, and after every major life event, like marriage, divorce, or the birth of a child. Marriage, divorce, new child. Update your forms right away to reflect your current wishes. Don't assume your lawyer or financial advisor did it for you. Always verify yourself. Remember, you are the CEO of your life and your legacy. Take just an hour to confirm these details. It's a small investment for peace of mind. By staying proactive, you can save your family years of pain, confusion, and potentially thousands in legal fees. Don't let a simple oversight undo your hard work. Protect your loved ones by keeping your beneficiary designations up to date. Many people create a living trust, but forget the most important step: funding it. A trust is just an empty bucket unless you put your assets in it. Funding means retitling your house, investment accounts, and savings into the trust's name. If you skip this, your assets still go through probate. I've seen people spend thousands on a trust, only for their estate to end up in court because nothing was transferred. Funding your trust takes work: new deeds, new account titles, paperwork. But it's critical. Your attorney should guide you or handle it. Don't leave their office without a checklist of what needs to be done. Follow up until every asset is in your trust. An unfunded trust is worthless. Do the work now, or your family pays later. 13. Estate planning isn't one size fits all. State laws matter. Community property versus common law states can change everything, especially in blended families. Taxes are another trap. Federal estate tax exemptions change, and many states have their own, often lower, thresholds. Some states tax inheritances differently based on your relationship to the deceased. Own property in multiple states. You could face probate in each one. A properly funded trust can help avoid this, but only if you know the rules. Don't use a generic will from the internet. Hire a qualified estate planning attorney in your state. They know the laws, the taxes, and the best strategies. Good legal advice is an investment in your family's future. Don't cut corners. Do it right the first time. 13. The biggest mistake? Keeping your estate plan a secret. Secrecy breeds confusion and suspicion. Your loved ones need clarity, not surprises when you're gone. Talk to your executor or trustee. Make sure they're willing and able. A family meeting is an act of love. You don't have to share every detail, but explain the big picture. Tell them where to find your documents, who your advisors are, and why you made certain choices. This prevents resentment and misunderstandings. Manage expectations now, not from the grave. Your estate plan is your final message to your family. Don't let it be cold and confusing. Let it be clear, loving, and honest. 13. Now, let's talk solutions. First, gather all your documents: will, trust, insurance, retirement accounts. If you can't find them, get copies. This is your financial inventory. Next, meet with a qualified estate planning attorney, someone who specializes in this. Bring your documents, asset list, debts, and family info. Be honest about your wishes. The attorney's job is to make your plan legally sound. Once your plan is updated, follow through. Fund your trust. Change titles and accounts. Create a letter of instruction. List passwords, safe deposit keys, and personal notes. Make sure your executor knows where to find everything. Commit to reviewing your plan every 3 years or after major life events. Your estate plan is a living document. Protect your family from chaos. Leave a legacy of love and security. The choice is yours. Be smart, take control, get it done.